Hi, folks. Welcome to today's webinar from Bob Benny Wealth Management. This is an educational webinar. We call it the Bobcast. My name is Bob Benny.
I'm Jessie Thompson.
We're both certified financial planners here in Lincoln, Nebraska. Our company is Bob Benny Wealth Management. And today we're going to be talking about Plan Today, Protect Tomorrow, Estate Planning Made Simple. We're going to talk about estate planning because it's a pretty important part of wealth management for people. And there's a lot of misunderstandings and misconceptions. And we help people a lot with estate planning advice. And hopefully this will be of help to you.
Yeah, so if you have any questions as we're going through things, you can type those in on the bottom of your screen. We'll wait till the end to address them all. And we just want to let you guys know, just in case you didn't know, that any of these webinars that we do every month, they're all available. The entire history of them is available. We put them on YouTube. And Hillary in our office makes little clips of them too. So there, if you don't want to watch a whole 30-minute video, you can just watch the clips that are important to you or interest you. So be sure to find us on YouTube at Bob Benny Wealth Management and like this video and subscribe so that you get notified whenever we have new videos or new clips that come out. So, okay, so let's go ahead and dive in. What's important when we're talking about estate planning is that everyone has an estate plan, whether they have legal documents for one or not. So let's talk about what exactly an estate plan is. What is that?
Well, it's a plan for the transfer of your assets after you're gone, right? And like Jesse said, if you don't have a plan like a will or a revocable living trust, which is what we prefer, and we're going to talk about a little bit, or we're going to talk about a little bit later, the state of Nebraska or whatever state you live in has an estate plan for you. And it may not be what you want. It probably wouldn't be what you want, actually. So what if you die without having any estate planning documents, Jesse? What happens?
Well, all of your stuff that didn't have a beneficiary on it. So this could be things like non-IRA investment accounts. This could be bank accounts, could be your home, cars, personal property, any other real estate that you have. If those didn't have a specific beneficiary arrangement on them, they'll have to go through the probate process, which is a state court process. And if you didn't have any legal documents drafted that tell the probate courts or avoid the probate courts completely and direct how you want your stuff to go. The state of Nebraska actually has a law. It's called intestate succession, which is their basically like automatic rules for where your stuff goes if you pass away without a will or a trust. And the way that that goes, like Dad said, might not be what you want. For example, something that's important is a lot of people, if they're married, they probably want, and maybe you don't have any kids from any other marriages or anything. It's just a simple, you guys are married, you have kids together. You probably want all of your stuff, if you died, to go to your spouse. And then when they die, the rest can go to the children, right? That's how a lot of people would probably outline things. Well, that's not how it works in estate succession in the state of Nebraska. Your spouse only gets about half of your stuff. And if you have children or surviving parents, they can get the other half. And so it might not be exactly what you want. It's important to have a plan, especially it's important to have a plan if you have kids that aren't grown yet. You don't want to leave that up to the court system of how they get taken care of.
Right.
So a lot of times when we meet people and we'll ask if they have an estate plan, they'll say, well, we had wills drafted up quite a while ago, but maybe they need updated, or we have wills. Is that enough? Is that enough of an estate plan to just have a will?
For most people, it's not, because a will is just simply a letter to the probate court. If you have a will and that's all you have, you're going through probate. Another thing we didn't mention is a lot of times people figure that, you know, owning things joint tenants with rights of survivorship is going to, take care of things. Well, that'll take care of you and your spouse. If the first one of you dies, the second one gets it. That's rights of survivorship. But eventually that person's going to die too. And then if they don't have a beneficiaries named and have a trust and whatnot, that's going to go through probate. If they have a will, it's still going to go through probate. Remember, a will is just a letter to the probate court.
So
it doesn't avoid probate.
You're making probate sound kind of bad. What's the matter with probate?
Well, number one, it's a public process. It's in court, it's public, all the information, all the documents are available that anybody can see. It costs money because and most of the money is not the court costs, it's the lawyer costs. And it's estimated that the cost ranges from between 3 to 10% of the estate. Well, you know, of course, if you have things like IRAs that have beneficiaries on them and they're not going through probate, but I bet nobody listening to this podcast named an unknown law firm as a 3% beneficiary of their IRA. Well, we don't want a known or unknown law firm to be the beneficiary of any of your money. And that's how we help people manage their wealth, is we help them to avoid unnecessarily paying to go through the probate process when, like I said, it's unnecessary. It's time consuming. Probate is. It takes 6 to 24 months, depending on different things. And like I said, it's public. So
do you mean if you have something that goes through probate, your beneficiary doesn't get that asset for up to maybe even 2 years?
Right. Because it's until it gets through the probate process, they don't get it. And you know, the way that things end up in probate, if you think about it, is a dead person's name is on the title of something. Okay, think about it. I have a car. I have a truck out in the parking lot. And let's say it's just in my name, Bob Benny. And Bob Benny dies. Well, your mom, Angela, my wife, she can't go and say, well, this is my husband's car, and so I want to sell it. It's frozen. It has to go through the probate process. And the probate court process is the legal process of determining who gets the truck. Well, maybe if I had a will that said if I die, everything goes to your mom, Angela, then yeah, she gets it eventually, and after having to pay to go through the probate process. And so that's the thing. It depends on how things are titled on whether they go through the probate process or not, with or without a will.
So what kind of estate plan can you have that would avoid that process?
Well, the most efficient for most people, and for most of the people that we help, is a thing called a revocable living trust. And the revocable living trust has tons of advantages versus not having one or having a will. What are the advantages of it, Jess?
Well, the biggest advantage is that it completely can avoid the probate process if it's done correctly and funded correctly, which we'll talk about later. Another advantage is that it keeps your family business private. The only people that get to know what's in your trust document are you, because you're going to be the trustees, and the successor trustee, whoever it is that you name to take care of all of your assets after you pass away. It's not a public document that everybody gets to see and know who you gave what to, that kind of thing. Keeps everything in the family. It keeps your assets in your control. As long as you are living, you are both the controller, the manager of the trust, and the beneficiary of the trust. Not all trusts are like that, by the way, but a revocable living trust is like that. You maintain control of all of it the entire time that you're living. And then it saves your family the time and money that the probate process costs them. And lastly, it simplifies things for your family when you pass away, so that they don't have to hire attorneys. They don't have to go through courts. They don't have to take all this time and go through all of this work just to get what you wanted to leave them. Instead, everything is much more streamlined and easily taken care of.
Right.
So Dad, can you show everyone what the mechanics are of how a revocable living trust works?
I sure can. So one thing I want to point out is the word revocable in revocable living trust. Revocable means you can change it. For instance, maybe one of you've got two kids and they're both 50-50 beneficiaries, and one of them just gets super duper wealthy and tells you, hey, I don't need any of your money, mom and dad. Why don't you leave everything to my brother or my sister? You can change that. If you want to change successor trustees, anything you want to, you can change in a revocable living trust. So here's I'm going to draw it on here. So here's this trust, okay? And here's our trust. Now, the trust has, the first thing you do, for instance, is you figure out who you want to be. Well, of course, the trustees to begin with are, like in our case, because her mom and I, Angela, are the trustees.
And the trustee is who's in charge
Yeah.
of all the stuff in the trust.
Same thing as
And can make changes
manager.
to it. Yep.
So no problem. Something happens to me, Angela's the trustee, okay? But we also named successor trustees, and we have 4 kids. And let's say that we name right now, we have ours, our successor trustee that we wrote in the trust is Jesse's older brother, Jake. And there's also an alternate. And let's say the alternate is Jesse. So if when we're gone, Jake has predeceased us, then it's Jesse. Jesse or any other successor trustee does not step in until both Bob and Angela are passed away. I want to point that out. Angela, if I'm gone or vice versa, whoever's of us is still alive, still is in total control, total beneficiary. Nothing happens until both of us are gone. But and then you have beneficiaries. So we have 4 kids. And there's 2 whose names start with J, Jesse and Jake, and then there's Sadie, and then there's Sam. I got 2 J's and 2 S's, okay? They all get 25%. Same. So what happens is you put things in your trust. You don't put everything in your trust. For instance, you don't put IRAs or 401ks in your trust. And I'll explain that. It's for tax reasons, you don't put them in the trust, and they're not going through probate anyway because they have beneficiaries agreements on them. But you do put things like real estate, like our house. Our house is in the trust, okay? My truck, here's my truck. Super cool. Here's Angela's car. It's cool too, but it's for a girl. If you have we don't have a farm, but if you have a farm, the farm would be in there. If you have investment accounts that are non-IRA accounts, a brokerage account, that's in there. And then your bank account is in your trust too. So this is the bank account. Okay. So everything's in there except for things like IRAs. There's an IRA over here and an IRA over here, and they already have beneficiaries on them. And when you pass away and that they send the death claim to the IRA custodian with the death certificate, that goes to these 4 beneficiaries, okay? Same with this one. But if you think about it, okay, when both Angela and I are deceased and the successor trustee takes over the trust, For instance, our house is titled in the name of our trust. Jesse, if she's the successor trustee, can go to a realtor and say, hey, this house over here on Saltillo Road was my mom and dad's. It's titled in the name of the Benny Family Trust. They're gone now, and we want you to sell it. So the guy's going to put the house on the market. He's going to sell the house. The person that buys the house is going to make the check out to the trust, which is just fine because Jesse's already gone to the bank. This is the bank. Jesse's already gone to the bank and taking control of that bank account by showing the trust, showing the death certificate, showing her ID. And so the house ends up, the money from the house goes to the bank. Money from the vehicles goes to the bank. The money from the brokerage account goes to the bank. Money from the farm goes to the bank, for instance, if that's how it's set up. And then all that gets split up 4 ways to the beneficiaries. Now, there's all kinds of different ways people can do it with, you know, maybe if you have younger beneficiaries that aren't, you don't want them to get it all at once, you can trickle it out or let them have it at different ages. And it doesn't have to be 25% a piece, or maybe, you know, one of the beneficiaries is going to get the farm. This person wants the farm, so they're going to get that. These other ones are going to split up the money, however you want to do it. And however you want to change it, because it's a revocable living trust. Is that all I'm supposed to go over?
That was good.
Okay, thank you. And thank you.
All right, so we wanted to show next a side-by-side comparison of a will versus a trust.
That sounds like a good idea.
All right.
That's the there you go.
So here's a comparison of a will versus trust. A will, these are just reviewing what we've already talked about, but a side by side. A will is public record. A trust is private to the trustees and successor trustees. A will requires probate and involves courts and lawyers. And a trust can completely avoid probate and avoids courts and lawyers. A will can be expensive and takes a lot of time to go through the probate process. A trust is cost efficient and time efficient for your beneficiaries. A will can pretty easily be contested in the probate court, and also can pretty easily be contested because, again, the probate court is an open process. A trust is, again, the business of the trustees and private to the trustees. And it can be contested, but it's a lot more rare. You can also include in a trust a no contest clause that basically says, if any of my beneficiaries or anybody wants to contest what I have laid out as my wishes in this trust, they only get $1. Because then it's a law specific thing that if they contest something,
right,
they can get something, but then the trust says all they get is $1 to avoid that. And then lastly, a will complicates asset transfer by involving the court process. A trust simplifies the asset transfer and makes things smooth for your beneficiaries.
So how do we set up a revocable living trust? That's what our next slide shows, I think.
Yeah.
Is that right?
So these are the steps to setting up a revocable living trust.
So first off, you have to decide on who the successor trustee or trustees are and who the alternates are, and who the POAs, that stands for power of attorney, who the powers of attorney are for finances and for healthcare. The power of attorney applies for while you're alive, and if you are incapacitated or incompetent. And so the assets that are in your trust are going to be taken care of by the successor trustee if you're incapacitated or incompetent. But you're going to have stuff that's not in your trustee or in your trust by design, like your IRA. We don't want that in your trust. But let's say that I have an IRA and I get the Alzheimer's and can't take care of myself. The power of attorney for assets, your mom, Angela, can manage and distribute that IRA for my benefit for me because she's the power of attorney for assets. Same thing. Everybody knows what a power of attorney for healthcare is. So number 2 is
Draft the legal documents, and we can help direct you with that, whether you have that done. A lot of times they're done by an attorney. Third,
we do them a lot online with people with an online thing that works and that they like it. That's inexpensive.
that has online lawyers. Yep.
Yep.
Third, you have to sign those legal documents a special way. They have to be witnessed by a notary and 2 witnesses.
And we help people with that. We call them a signing powwow. It takes about 45 minutes to sign and witness and notarize all the documents and all that stuff. We do it here in the office. And then number 4, you need to fund the trust. What's the matter?
That's how all the stuff gets into your trust.
Right.
Is by this process. It's super important.
Yeah. So you could have a trust and everything could be hunky-dory and everything, but if you didn't fund the trust, meaning changing the titles on the stuff you want to be in the trust, like when we did ours 25 years ago or whenever, we changed the title of our house from Bob and Angela Benny Joint Tenants with Rights of Survivorship to the Benny Family Trust. Same thing with ownership of Bob Benny Wealth Management. It's owned by the trust. Same thing with our vehicles, owned by the trust. Bank accounts, owned by the trust. All that stuff. So that's very important in order to get the trust to avoid or to get the asset to avoid probate. We don't want a dead person's name or a person's name that's eventually going to die on the title of the asset, because when they die, that's how stuff ends up in probate is if a dead person's name's on the title of it. Think about it. Your name is on the title of your car, or it's joint name, and your spouse dies. Now your name is on title of the car and you die. Now we have a titled asset, title in the name of the dead person. Nobody can sell it. Nobody can take it. It's frozen. It has to go through the probate process. That's what we're trying to avoid. The hassle of probate and the expense of probate. So.
All right. So lastly, we want to talk a little bit about estate taxes and how they work. So do you think many people will have to pay estate taxes?
Most people, the vast majority of people that are our clients anyway, don't have a high enough net worth right now, according to current law, that they'd have to pay estate taxes, because the federal estate tax exemption is almost $14 million right now. And so that's per person. So for a married couple, that's $28 million. We don't have very many people very many customers that have it. And generally, the people come in here, most of them don't have estates near that big. If they do, we have other solutions to help them with advanced estate planning to minimize or eliminate federal estate taxes. But that exemption amount per person of almost $14 million is part of Trump's tax cut or tax overhaul of 2018, set to expire in 2025. And what happens then, Jess?
It's probably so.
If it expires,
it's going to go back to the original amount indexed for inflation. The original amount was like 5-something million per person. They've been indexing it for inflation. When Trump did all of his tax cuts in 2018, he doubled it from what it was at that time. So if it doesn't get extended, it's estimated that it'll go back to around $7 million per person instead of the 14 million that it is right now.
So that's the amount that you can leave as estate tax free. Everybody's got to remember, we're not talking about income taxes. We're not talking about capital gains taxes. We're talking about a special tax called estate taxes, which is designed to tax rich people.
And it's on the whole of everything that you leave in your estate. So even things that are going to be taxed anyway to the people that you leave them to, like your IRAs, when you leave them to a beneficiary, any money that they take, they have to take the money out within 10 years, and any money that they take out of it is going to be fully taxable. Well, even that money is included in this other tax that can get really high really fast. The estate tax rates go up to 40% like that.
Yeah. And, I mean, that's why people want to avoid them. It's a very unfair tax because you've already paid tax on the money when you earned it or when you sold something for a profit and paid a capital gain tax on it. You paid property taxes, maybe if it was real estate all along, you were taxed, and then you die and the government wants to grab 40% of it. That's not fair. And part of our job as certified financial planners and with Bob Benny Wealth Management is to try to help people be as good of stewards of their wealth as we can and avoid legally, of course, unnecessary state taxes and stuff like that.
Yep, and there's different types of trusts than the revocable living trust that we talked about today that can help people if they're in that,
right.
If they have that problem. It's a good problem to have, but
yeah. But another thing people don't think about too, Jesse, is somebody might have a great big death benefit on a life insurance policy. Well, if let's say that the estate tax exemption is $7 million and you've got exactly $7 million and you die, except for in addition to the $7 million, you have a $5 million death benefit life insurance policy and you die, so you have an estate worth $7 million. But the way the IRS treats that death benefit, they add that onto your taxable estate, and they're going to tax that $5 million at about 40%. So $2 million of your $5 million, that's the kind of thing we try to help people figure out and avoid. So
yeah.
We have a few other.
One more quick thing that I wanted to mention along with that too is that the estate tax and the gift tax are tied together. So that amount of money that you can leave tax-free to your kids, that's how much money, the gifts that you give them while you're living is included in that amount. So you can't say, well, I'm just going to start giving all of my money to my kids before I die to avoid this estate tax problem. All of that is recorded in how much you've given is recorded when you go to do your estate taxes, and it's included in that. They're tied together and combined. So
we know all about all this stuff, and we would like to help you and not get too into the weeds on all the different kind of details. But
we had a couple of other little questions or important things that we find we talk about with people in these estate planning appointments that we wanted to mention. One of them is, how can someone pick their successor trustee if it's not like I know for sure that I'm going to choose my oldest kid or whatever.
Yeah, we help people figure that out. And for instance, we like it to be one of the beneficiaries because they have them and the other beneficiaries' best interest at heart more than anybody else.
Mm-hmm.
But sometimes that doesn't work. Like if your beneficiaries are your kids and they're too young, to be a successor. What you want with a successor trustee is somebody that's competent and trustworthy. Typically, for most of our customers that we help with these, it's one of their children, maybe their oldest child. Maybe you have, for instance, one of your kids is a CPA. That'd be a perfect successor trustee. One of the things we try to avoid, like the plague, is having what's called a corporate trustee, which is a bank or a trust company, be the successor trustee. Why do we avoid that?
They don't necessarily have your kids or your beneficiary's best interests at heart. And it's advantageous for them to drag out the process as long as possible because they get a collective fee for being the trustee. You're paying them to be the trustee. They're collecting that from the trust as long as it's open.
So I've been doing this for helping people with estate plans and trusts for about 25 years of my almost 30-year career, and I pretty much know the ins and outs of how to do this, and we'd love to help you and or your friends or anybody answering questions or helping you set these things up. what are other kind of documents that people need besides a trust in an estate plan, Jess?
They need their power of attorney for finances. You need a power of attorney for healthcare. You need a living will. That's basically instructions that if something happens to you and you're on your deathbed, your kids don't have to make decisions to let you off of life support or stop feeding you, pull the plug, things like that, that are awful decisions for a child to have to make for their parents. You can make those decisions ahead of time so that they don't have to make those in a living will. The last thing is a pour over will, and a pour over will is basically like a safety net for in case you forgot to put anything in your trust and you passed away. That stuff doesn't have to go through as long of a probate process because you have this will that's, again, it's a letter to the probate court that says all of this stuff, anything that I have that I didn't put in my trust, I meant to put it into my trust. So I want it all to go to my trust, and it should shorten the process of that.
So that's about all we have. We don't have any questions on there, but we just want to remind everybody that we're just here to help. We'll help with answering questions, sitting down with you or your friends or family about these kind of financial matters or investment matters or retirement income planning matters or anything like that. God put us here to help people, and we know that, and that's what we try to do. What do we also want to encourage them to do, especially if they're watching this on the YouTube?
If you're watching this on YouTube and you're watching the replay, be sure to like and subscribe so that you get alerts, and it helps the algorithm so more people can get our free help.
So
right.
Thank you very much for watching the Bobcast today, and hope you have a blessed day.
Thank you.